If you were born before 1958, I need you to stop what you are doing right now and stay with me for the next 11 minutes because there is a very real chance that the 5-year window the federal government gave you to protect your home from nursing home seizure is already closing. Not next year, not when you retire, now. Every month you wait is 1 month shaved off the only legal protection that exists, and nobody from the government is going to pick up the phone and call you to tell you about it. That is not how this system works. The system waits silently while the clock runs, and by the time your family finds out the window has shut, the house is already gone. Today, I am going to show you exactly how this window works, how to calculate how much time you actually have left, and the specific steps you take to start the clock before another month goes by. Stay until the end. The last step is the one almost nobody takes, and it is the only step that actually locks the door permanently. If you are not subscribed yet, do that right now and turn on the bell. Medicaid rules, look-back regulations, and estate recovery procedures change every single year. When they change, nobody from the government explains what it means for your specific situation. That is exactly what this channel does. Subscribe, and let's get into it. Before I get into the details, let me tell you about something that happened last year that I think about a lot. A retired electrician in Pittsburgh named Frank had been planning to set up an irrevocable trust for almost 9 years. Every time he mentioned it to his wife, she would say they should wait until they were a little older, a little more certain about their health. Frank was 71 when he first brought it up, then 73, then 75, then 77. Last February, at age 80, he finally called an elder law attorney. The attorney reviewed his situation and told him the truth. If Frank set up the trust today, the 5-year clock would not expire until he was 85. The average age at which Americans enter a nursing home is 79. Frank was already past it. The window had not just closed. It had closed 3 years ago and nobody told him. 6 months later, Frank had a fall. He needed skilled nursing care, $9,700 a month, $116,000 a year. The house his wife still lived in became a countable asset. There was no protection left. Frank's story is not unusual. It is, in fact, far more common than most people realize. And the reason it keeps happening is the same every time. Nobody told him the clock had already started running out. Here is the foundation of everything I am going to explain today. The federal government gave every American senior a single legal tool to protect their home from Medicaid estate recovery. That tool is called an Irrevocable Medicaid Asset Protection Trust. You transfer your home into the trust. The day you sign, the 5-year clock starts. If you do not need nursing home care for 5 years and 1 day, the house is protected. Medicaid cannot touch it. Your kids inherit it. The state gets nothing. The letter never arrives. But here is where the problem starts. That 5-year clock does not start when you first think about protecting your home. It does not start when you call an attorney. It does not start when you mention it to your spouse. It starts the day you actually sign the trust and transfer the property. And according to research published by the American Bar Association, the average American senior waits until age 76 to begin estate planning conversations with an attorney. By 76, the window is essentially shut. The average nursing home entry age is 79. That leaves 3 years. The trust needs 5. The math does not work. One analyst ran the numbers and found that fewer than 15% of seniors who could benefit from an irrevocable trust actually set one up in time. Over a 20-year retirement, that is hundreds of thousands of dollars in home equity lost to estate recovery. Not because the tool did not exist, because nobody told them to start the clock. Now, I want to tell you about the practical companion to everything in this video. The Inheritance Quick Shield Guide walks families through every step of the 5-year window. The timeline calculator that shows your exact remaining months of protection, the irrevocable trust consultation checklist, the transfer on death deed walkthrough for your specific state, the look-back audit worksheet. The outcome is simple. Your kids inherit the house you spent your life paying off. The state gets nothing. The letter never arrives at their front door. Link is in the description. Now, let me add the second layer to this, because for people born before 1958, there is a specific timing reality that has quietly cost millions of families their homes. And it comes down to one calculation that most people never fully understood. If you were born anywhere before 1958, you are currently 67 years old or older. That is the exact age where the planning window is wide enough to use but starting to narrow. Let me walk you through the math. If you are 65 today, you have a full window. 5 years gets you to 70. The average nursing home entry age is 79. You have 9 years of buffer. The window is open. If you are 68 today, the window still works. 5 years gets you to 73. You have 6 years of buffer. The window is open, but starting to close. If you are 71 today, the window is getting tight. 5 years gets you to 76. You have 3 years of buffer. The window is closing. If you are 73 today, the window is almost shut. 5 years gets you to 78. You have 1 year of buffer. 1 year, one health event, one fall, one stroke. The window is essentially closed. If you are 75 or older today, the irrevocable trust strategy no longer works for you. The math is over. You need different strategies: a transfer on death deed, a caregiver child exemption, a ladybird deed if your state allows it, half a loaf planning if you are already in crisis. But the gold standard protection is gone. Here is the problem. Millions of Americans in this birth year range were never clearly told that the 5-year window starts on the day they sign, not on the day they first considered it. What many of those people were never clearly told is that waiting even one additional year can be the difference between full protection and zero protection. If you claimed Social Security at 62 thinking you had plenty of time, you are not alone. The same psychological delay that costs people hundreds of dollars a month in Social Security benefits also costs them hundreds of thousands of dollars in home equity. The pattern is identical. Wait. Then one day you cannot wait anymore, and the option is gone. Last spring, a woman in Denver named Catherine posted in an elder law forum that she had set up an irrevocable trust at age 67 after her husband passed. She said she almost did not do it. Her brother told her it was overkill. Her financial advisor said she was too young to worry about it. She did it anyway. 5 years and 1 month later, she was diagnosed with early-stage Alzheimer's. By the time she needed full-time care at age 74, the trust had matured. The house was protected. Medicaid paid for her care. Estate recovery could not touch the property. Her adult son inherited the home she had lived in for 38 years. Catherine said, and I am paraphrasing what she shared publicly, that the attorney who set up the trust never sat her down and said, "Here is what this decision saves you 10 years from now." She just signed the paperwork and hoped she would never need it. She said she wished someone had explained it the way her son finally did, 30 minutes over coffee, after the diagnosis came in. That story hit a lot of people because it is not an edge case. It is the textbook example of doing the right thing at the right time, and it has a specific shape for people in this birth year range. Now, I want to be direct about something. If you are already 73, 74, 75, I am not here to make you feel bad. What I am here to do is show you that there may still be protection available for reasons that have nothing to do with the irrevocable trust. Because here is what most people do not know. Even if the 5-year window for the trust has shut, even if you waited too long, even if your health is already declining, there are still tools that work. And that is the fixable part. That is the part an elder law attorney can actually do something about if you bring them the information before the crisis hits. So, here is what I want you to do. And this is the part of the video you should be writing down. The first thing is to calculate your exact window. Take your current age, add 5 years. That is the age you would be when an irrevocable trust matures if you signed one today. Compare that number to 79, the average nursing home entry age. If your number is below 79, you still have a window. If your number is above 79, you need alternative strategies. This takes about 30 seconds. Do it before you finish this video. The second step is to check whether your state offers a transfer on death deed. Over 30 states plus the District of Columbia do. This is the strategy that works regardless of your age. There is no 5-year clock on a transfer on death deed. It takes effect the day you file it. It bypasses probate. It costs nothing in most jurisdictions. It takes about 15 minutes to fill out. If you are already past the irrevocable trust window, this is your next move. The form is available through your county recorder's office or your state's bar association website. The third step is to schedule a consultation with a qualified elder law attorney, not a general practice attorney, not the attorney who drafted your will, an elder law attorney. The consultation typically runs 60 to 90 minutes. Bring your deed, your last 5 years of bank statements, your beneficiary forms, and your tax returns. The attorney will tell you within one visit whether the irrevocable trust is still viable for you or whether you need to pivot to alternative strategies. You can also call your state's bar association and ask for a referral to a certified elder law attorney in your county. Now, here is something important about timing that I do not want you to miss. While some strategies can still work even after a crisis hits, the irrevocable trust only works if you set it up before you need care. Once you are in a nursing home, once you have applied for Medicaid, once the look back is being run, it is too late. The clock cannot start when you are already in crisis. The federal rule is strict. The transfer must happen when you are still healthy enough that Medicaid cannot argue you transferred it because you knew you needed care. This is not a reason to panic. It is a reason to move on this sooner rather than later. If Frank in Pittsburgh had called that attorney at age 71 instead of age 80, the house would be protected today. I also want to address something that comes up every time I cover this topic, which is the question of giving the house to the kids instead of using a trust. Many people think this is a shortcut. Just add the daughter to the deed. Just sign the house over to the son. Avoid the attorney fee. Avoid the trust complexity. Here is what happens when you do that. The moment your child's name goes on the deed, your home becomes vulnerable to their divorce, their creditors, their lawsuit, their bankruptcy. They are now a partial legal owner. Their problems are now your problems. And from a Medicaid standpoint, the transfer is treated as a gift. If it happened within the 5-year window, you get hit with a penalty period that can force you to spend down assets you thought were protected. There is no shortcut. There is only the right way and the wrong way. In May of this year, a report from a government oversight office confirmed that thousands of families had lost their homes, not because they failed to plan, but because they used the wrong planning tool. The most common mistake was adding an adult child to the deed instead of using a transfer on death deed or an irrevocable trust. The report estimated that roughly 40% of deed transfers between parents and adult children created unintended Medicaid penalties. 40%. That is not a rounding error. That is a systemic problem that the government quietly acknowledges when pressed, but does not go out of its way to publicize. This is the part I want to stay with you after this video is over. Medicaid is not your adversary. The estate recovery program is not malicious. Most of the people who work there are trying to do their jobs, but the system is enormous. It is complex. It was built on decades of federal mandates and state-level bureaucracy. And the honest reality is that it takes homes from real families every single day because those families waited too long. The burden of starting the clock does not fall on Medicaid. It falls on you. And the only way you start it is by signing the right document before the crisis hits. If you were born before 1958, your window is either open, closing, or already shut. Your home was supposed to be protected by planning you started in time, correctly structured and correctly timed. Before you close this video, take 30 seconds to calculate your window. Add 5 to your current age. Compare it to 79. If you still have time, call an elder law attorney this week. If you do not, file a transfer on death deed this week. Either way, do something this week. Not next month. Not next year. This week. Send this video to one person you love who was born before 1958 and owns a home. One share takes 10 seconds. If their window is still open, catching it could save the family home permanently. Money the state has been positioned to take without sending a single letter to warn them about it. That is what this channel is here to do. If this made a complicated topic easier to follow, subscribe and hit like. The Inheritance Quick Shield Guide has the checklists, the audit worksheets, and the document templates we covered today. Link is in the description. I will see you in the next one.